Good morning. Happy Tuesday. I figured we'd play a little game of good cop, bad cop. And we're going to use videos from a video from today by Tim Pool, where he slammed the St. Louis police for the way, well, I guess technically he slammed an attorney out of St. Louis, McCloskey, who basically said the police were just doing their jobs and he didn't have a problem with the police. And we're going to compare and contrast that to a video that Van Balen put up where they arrested and I'm using Van Balen's terminology, a cop baiter. So the McCloskey one. Let's start off with facts, because the facts always matter. The McCloskeys own a mansion. They purchased about 30 years ago. They spent a lot of time and money and effort refurbishing it. It's a historical building, I guess. Anyway, one day, a week or two ago, a parade, a group, a bunch of Black Lives Matter protesters entered their clearly marked private property by opening a gate. It's a fenced-in area surrounding their home. And we're there chanting, whose streets are streets, and apparently, allegedly, they were making threats against the McCloskeys, who came out with firearms. He was holding a rifle that is an AR-15 style rifle. I don't know if it's an AR-15 or not. She was holding a semi-automatic pistol of some variant. I don't know what make or model or caliber it was. And these two people defended their home. They didn't shoot at anybody. Apparently, they have poor muzzle control, but what are you going to do? There's people on their property who are refusing to leave for the most part. Eventually, they did leave. But then the police came back with a warrant for the rifle. Police came back with a warrant for the rifle. They took the rifle. Now, according to Mr. McCloskey, who's an attorney, the charges are there. An indictment is impending. There's going to be an indictment soon, he believes. So Tim is just all, just hating on this McCloskey and hating on these police officers for clearly violating the Constitution by seizing these firearms just because the McCloskeys used them to defend themselves. I believe only the rifle was taken. The pistol may have been. Who knows? Doesn't really matter. So what is the problem with that? Well, again, Tim Pool, he's a better journalist than I'll ever be, but he's not a lawyer. He'll admit to you he's not a lawyer, but for some reason, people still think that they know and understand what's going on when they have incomplete facts and they don't fully understand the Constitution and its limits and the case law around it. What happened was the officers got a warrant. Now, it may not have been the officers getting the warrant. It may have been the DA who got the warrant, but a warrant was issued. And warrants don't just appear. It's not just like somebody types it up and all of a sudden it's a valid thing. It went in front of a judge. A judge looked at the warrant, probably questioned the affiant or affiants, the people who were making the statements. And the judge, after viewing the warrant and listening to the affiants, issued the warrant, determining that there was, in fact, probable cause that a crime was committed. Now, I don't know what probable cause there was for what crime. For all I know, that after the cops responded to the BLM protesters being on the private property, one of the cops may have noticed or saw that there was a selector switch on the rifle. You don't know. I don't know. I haven't seen the warrant. But a judge determined that there was probable cause. So it is not a violation of the Fourth Amendment. You can seize somebody's guns if there is a violation of law where it allows for it. And in this case, there was a warrant that issued. So there was no constitutional violation. And if there was a constitutional violation, it would not be on the part of the police, presumably, unless they lied to get the warrant, but it would be on the part of the magistrate or judge who granted the warrant. So it's misplaced. And to be perfectly blunt with everyone, either you're for the rule of law or you're against it. And there are a lot of people who are like, oh, well, BLM is breaking the law. These rioters are breaking the law. Tim Pool was going on and on about how the police should just let them burn the city down. That's not the police's job. It's not the police's job to determine who gets charged with a crime and who doesn't. It's a grand jury. And if the grand jury returns a no bill, if they say no, we're not going to indict somebody, that's the fault of the system, but that's the rule of law. And the people of Portland, the people of Seattle are going to have to deal with this situation. They're going to have to deal with releasing criminals, arsonists and murderers and rapists and things like that back out into their city. They're the ones who are going to bear the cost of that. So that's me defending the cops, the good cops, the cops who are actually following the law and executing a warrant that was properly issued, or at least I have no indication to believe it was improperly issued. So what about bad cops? Well, we were talking about a Van Balen video. He titled it, "Cop Baiter Gets Arrested, Tells the Police something along the lines of, I was waiting for this." That's roughly the title. In this video, of course, it starts off in media res. We don't see what was going on before. It starts off in the middle of the action. And by saying in the middle of the action, what I mean is that there was no action going on. The video starts with the officer approaching a car with the doors open. The car is stopped. The occupants have apparently been removed from the car and are now sitting behind the car. Another officer is questioning them, which leads me to my next point: don't talk to the police. So there's a second officer who we won't discuss further, talking to these people quietly, calmly. There is no action going on. There is no agitation going on. There is no one interrupting that officer in the performance of his duty. But the new officer that walks up, he stops, the camera pans, and we see in the distance a cop watcher who is recording the stop. The officer takes, as near as I can count it, about 15 purposeful strides. Now I'm 6'2", my purposeful stride is over 3 foot. So I estimate that cop went 45 to 50 feet. Or the cop watcher was 45 to 50 feet away from where that cop started, is a better way of stating it. And the cop did not stop chest to chest with him. He stopped, arm's length away, close enough that he could lay his hands on the cop watcher. When he reached that point, he began to order the cop watcher to move back an arbitrary distance, because apparently approximately 50 feet wasn't enough for these cops to feel safe. Lone cop watcher, one man, not yelling, not doing anything other than filming the police. Well, the cop watcher, it is Van Balen's channel, so you can assume that the cop watcher said some stupid shit. And the cop watcher said that there's a 25-foot rule. There is no 25-foot rule in Texas, at least as far as I'm aware. And yes, this was filmed in Texas. It's about as naive as saying there's a 10-foot rule because of Glick v. Cuniff, but that was just dicta. So the videographer refuses to move back, and the cop arrests him for interfering with the public duties of a police officer in the performance of his duties. And people in Van Balen's chat, and Van Balen himself presumably, were applauding this. Van Balen called this guy a cop baiter. The guy was just recording the police, wasn't saying anything, wasn't actively inserting himself into the situation. He was a respectful distance back, quietly recording the police. The officer who arrived on the scene made that cop watcher a part of the action. The cop watcher didn't insert himself into it. The cop inserted the cop watcher into the action. There was no interference. Now, I don't know why, but I've read a lot of case law in Texas for interference with the public duties of a police officer. And all the case law out there deal with one of two situations. One is where you are lawfully detained for something else, lawfully detained or lawfully arrested for something else, and refusing to obey the orders of the officers. Or number two, it's if there is an actual issue going on. If you are inserting yourself, or if there is agitation, upset, violence. For example, there's one case that I read. It was a fairly recent case. Cop watchers who were also Second Amendment activists were filming a police encounter, and they were armed, and the police were like, "No, you've got to disarm, basically, if you want to be viewing this." And one of the videographers, one of the cop watchers, refused to disarm. He thought that he was safe because it was a black powder pistol or something, and the court said no. The police were justified there. There was a large crowd. It was getting agitated, riled up. There were tensions there. Other situations are where there are tensions there, or when a person actually directly interferes by trying to release a suspect, a detained suspect, by trying to interfere with the cop while the cop is talking to someone, like directly interfering with the witnesses by pushing them away, or by otherwise obstructing the officers from being able to get to them, etc. It is never just calmly standing there filming. Now, in the statute, in the public interference statute, speech itself speech without anything more cannot be the basis of an interfering with public duties charge. And I would posit to you that him standing there filming was not interfering. Now, of course, the cops are going to say, well, once we ordered him to move back and he refused to move back, that's when the problem was. But here is my best guess for you. My best guess for you is a DA is going to view this. And the DA is going to see not just the body cam footage that Van Balen showed, but also the footage of the guy who was recording. And we're going to get a better clue, a better idea of how long that man was peacefully recording from a distance. And then we're going to see that cop made a black man standing on the corner peacefully recording the police, presumably in the wake of the George Floyd murder, where a man was killed, and the way we know he was killed was because people peacefully recorded the police. And I'm pretty sure that no DA is going to indict him, and that no jury would convict, and what he did was not a crime. But the bootlickers in Van Balen were very happy that a man got his rights violated. There's a clearly established right in the Fifth Circuit to record the police, especially recording the police in the performance of their public duties while they are in public. And while the recorder is on a public sidewalk, a traditional public forum. I mean, it's just a clear-cut case of the police violating someone's right because they wanted to, be assholes. Anyway, that was your good cop, bad cop. In case you're wondering why I don't make videos more often, I only make videos when I think I have something to add to a situation. I don't make videos just to make videos. I make videos because I want to make the video and because I have something to say. Something to say that I think hasn't been said or isn't being said right, or something along those lines. And of course, you're free to disagree with me. I'm sure you will. But thanks for watching and have a great day.